Hey everybody, Zach Wolf here with another great Top 5 Tuesday. This week on Top 5 Tuesday, it's the top 5 things you need to know about the impracticability defense in contract law. What does that mean? Well, impracticability is a little bit like impossibility. The question is, when you sign a contract and later your performance of that contract becomes impossible or impracticable because of some event outside your control, are you still obligated to perform the contract? Now, those of you who watched my previous video may be thinking, that sounds a lot like the force majeure concept that Zach talked about in his other video. And it's very similar to that. But there's a difference. Impracticability of performance is a concept that can apply regardless of whether the contract has a force majeure clause in it. So even if there's no force majeure clause, if performance becomes impracticable, you may have an argument that the performance is legally excused. Okay, so that's impracticability. But what do you need to know about it? Well, let's start with number 5. And that is that the general rule of contract law is that impossibility of performance is not a defense. Generally speaking, if a contract provides that a party has an unconditional obligation to render some performance, then that party is obligated to render that performance regardless of whether it becomes difficult or even impossible. Let me give you an example. Let's say you own a hotel in the Houston, Texas area where I live and work. And let's say you sign a contract with the Texas Quilting Association to host their annual convention. The week before the convention, the air conditioning system in the hotel crashes. It isn't working. And so it's going to be impossible or impracticable to host that convention. Is that an excuse? Well, the general rule is no. So that's the first thing you need to know about the impracticability defense. The number 4 thing you need to know about impracticability is that Texas courts have recognized Section 261 of the Restatement of Contracts. That section says that there is an exception to the general rule I just mentioned, and that exception is the impracticability defense. That section says that when a party's performance of a contract is rendered impracticable without that party's fault, because of the occurrence of a condition, the non-occurrence of which was a basic assumption of the contract, then the party is excused from rendering that performance, unless the language or circumstances indicate otherwise. Okay, that's a mouthful. So what does that really mean in practical terms? Well, let's take an example from a case that applied Section 261. In the case Centex versus Dalton, the court said that Section 261 applied where a government agency action made performance impossible. The contract provided for paying a fee to a consultant, but a federal agency prohibited that payment. So in that situation, the performance of the party who was supposed to pay was excused. The number 3 thing you need to know about impracticability of performance is that the kind of event or occurrence that meets the standard for impracticability is going to be fairly narrow. There's a Texas case called Tractebel Energy that laid out the typical things that could establish this impracticability defense. And that case mentioned three things. One is death of a party. Second is destruction of an item that was required for performance of the contract. And the third is government regulation. So think of it as death, destruction, and taxes. Those are the three kinds of things that are the classic examples of impracticability of performance. The number two thing that you need to know about impracticability of performance is that the party relying on the impracticability defense still has to show it used reasonable diligence to perform the obligation at issue. So you can't just cite some event that nobody expected that you say prevented performance and then say, oh, my hands are tied, I can't perform. You've got to show that you made a reasonably diligent effort to perform despite that unexpected occurrence. So in the case of our hypothetical Houston hotel owner, if the air conditioning system goes out the day before the convention, did the hotel exercise reasonable diligence to fix the air conditioning system? Did it look into bringing in some temporary system that would serve the same purpose? Those are the kind of questions that will be asked to figure out if the party seeking to excuse performance exercised reasonable diligence. And finally, the number one thing you need to know about the impracticability defense is that courts are usually skeptical of the defense when it is based on the inability to raise money. So for example, if the parties sign a contract and they're expecting that one party is going to obtain financing in order to perform its financial obligations under the contract, that party's inability to obtain financing is usually not going to be the kind of excuse that satisfies the impracticability defense. Of course, there can always be exceptions. So those are the 5 key things you need to know about impracticability of performance. If you liked the video, hey, please hit the like button or share a comment, or even better, share this video with someone you know. And hey, thanks for watching.